Rehabilitation for persons who are inadmissible to Canada because of past criminality. Determining inadmissibility. Are you inadmissible because of past criminal activity from your home country or in Canada and you are a foreign national? In general, temporary residents and applicants applying for permanent residence are considered to be criminally inadmissible if the person was convicted of an offense in Canada, was convicted of an offense outside of Canada that is considered a crime in Canada, or committed an act outside of Canada that is considered a crime under the laws of the country where it occurred and would be punishable under Canadian law. Have you been charged, discharged, or pardoned? What I'm going to talk about right now will help you determine if you are inadmissible if you have been charged, discharged, or pardoned. For charges withdrawn or dismissed, if the offense occurred in Canada, you are not inadmissible. If the offense occurred outside Canada, you may be inadmissible. For an absolute or conditional discharge, if the offense occurred in Canada, you are not inadmissible. If the offense occurred outside Canada, you may be inadmissible. Pardon granted. If the offense occurred in Canada, you are not inadmissible if you were pardoned under the Criminal Records Act in Canada. If the offense occurred outside Canada, you may be inadmissible. If you may be inadmissible, you must provide an officer with complete details of all charges, convictions, court dispositions, pardons, photocopies of applicable sections of foreign laws, and court proceedings to allow the officer to determine whether or not you are inadmissible to Canada. I just want to make a note in here. The term pardon has been replaced with record suspension. That was on March 13, 2012 when they changed that. The good news is that you can overcome criminal inadmissibility. Let's discuss about the criminality. Convictions, offenses outside Canada. If you were convicted or committed a criminal offense outside Canada, you may overcome this criminal inadmissibility by applying for rehabilitation, or you may be deemed to have been rehabilitated at least 10 years have passed since you completed the sentence imposed upon you or since you committed the offense. If the offense is one that would, in Canada, be an indictable offense punishable by a maximum term of imprisonment of less than 10 years. If the offense is one that would, in Canada, be persecuted summarily, and if you were convicted for 2 or more such offenses, the period for rehabilitation is at least 5 years after the sentences imposed were served or are to be served. Convictions or offenses in Canada. If you have a criminal conviction in Canada, you must seek a record suspension, or they call it formerly pardon, from the Parole Board of Canada, PBC, before you will be admissible to Canada. That is a conviction inside Canada. How about convictions or offenses outside of Canada? If you have convictions in Canada and convictions or offenses outside of Canada, both an approval of rehabilitation and a pardon are required to overcome your inadmissibility. Note, your request for rehabilitation cannot be made until you have first obtained a record suspension, except if you have only one summary conviction in Canada. In such instances, you may have submit an application for rehabilitation for any conviction or offenses outside Canada if you can provide evidences that you have submitted an application for a record suspension to the Parole Board of Canada or PBC. Rehabilitation. What is rehabilitation? Rehabilitation removes the grounds of criminal inadmissibility. Rehabilitation means that you lead a stable lifestyle and that you are unlikely to be involved in any further criminal activity again. You are eligible to apply for rehabilitation if you have committed an act of Canada and 5 years have elapsed since the act, been convicted outside of Canada, and 5 years have passed since the end of the sentence imposed. Eligibility for rehabilitation. This section gives a summary of the type of offenses and length of rehabilitation period. If you were convicted of an offense outside Canada, that, if committed in Canada, would be an indictable offense punishable by a maximum term of imprisonment of less than 10 years. You are deemed rehabilitated at least 10 years after completion of the sentence imposed. You are eligible to apply for rehabilitation 5 years after completion of the sentence imposed. How long will that take? It's gonna be 1 year or more. If you committed an offense outside Canada that, if committed in Canada, would be an indictable offense punishable by a maximum term of imprisonment of less than 10 years, you are deemed rehabilitated and, of course, at least 10 years of completion of the sentence imposed. You are eligible to apply for rehabilitation 5 years completion of the sentence imposed. If you were convicted of an offense or you committed an offense outside Canada that, if committed in Canada, would be punishable by a maximum term of imprisonment of 10 years or more, you are deemed rehabilitated. That's not applicable anymore. Remember that. You will gonna be forever barred in Canada, forever inadmissible. You are eligible to apply for rehabilitation 5 years from completion of the sentence or commission of the offense. If you were convicted for 2 or more offenses outside Canada that, if committed in Canada, would constitute summary conviction offenses, you are deemed rehabilitated at least 5 years after the sentence imposed were served or to be served. You are eligible to apply for rehabilitation? No, not applicable. Note: to be rehabilitated, the person must not have committed or been convicted for any other indictable offense again. If you have a criminal conviction in Canada, you must seek a record suspension, formerly a pardon, from the Parole Board of Canada or PBC before you will be admissible to Canada. The question is: coming to or remaining in Canada without approval of rehabilitation. This is what will gonna happen. If you need to come to Canada but cannot apply for rehabilitation because of 5 years have not passed since the end of the sentence imposed, or if you are not eligible to apply for a record suspension, formerly pardon, for conviction in Canada, you may request special permission to enter or remain in Canada. To do this, application complete criminal rehabilitation or IMM 1444, and make sure you check the box state for information only. Attach all the documents outlined in the document checklist. Note: there will be processing fees for that rehabilitation. After the officer reviewed that, and then what they happened and your current situation, then the officer will advise you according to the following: at Canadian Visa Office outside of Canada or port of entry, or in Canada. Well, again, you can always message me below or share this explanation to anybody who have been deemed inadmissibility because of previous crime that they committed inside or outside Canada. I hope nakatulong po ako. This is Norlyn Oligosarma, your licensed immigration consultant.